We're going to come to an end of presentations by individuals. Now I want to get into a little bit of conversation. And if there's any questions in the audience, feel free to raise your hands. One of the things that I was thinking of when listening to Dennis talk about employment policies was the analogy to corporate or commercial contracts. So at what point does accessing a computer, perhaps in violation of a contract, become a criminalized conduct? And we have one present prosecutor, one former prosecutor, and one present defense attorney on the panel. And so I'd like to ask them, and maybe we can start with Vicki, how do you interpret, how do you use the Computer Fraud and Abuse Act when it is something that is a contract violation in the commercial field, and then perhaps decide to turn that into a criminal prosecution? Do you?
Sure. So first, everything I say here is my personal opinion, not the opinion of my office or the department. But before getting into the specifics of that, one thing I wanted to discuss that I was thinking as Dennis was talking was that there's so much focus paid to the definition of exceeding authorized access that I feel like the conversation has really moved away from what we understand in most criminal activity, which is that this is about criminal intent. You know, like the question about when you're looking at a mail fraud offense or looking at the mail fraud statute, people don't have big questions about what it means to use the mails because it's understood that what the government is going to go after is going to be criminal conduct measured by an individual's intent. And so I start with that because when you're looking at what the intersection would be between the contract that someone has with their employer or the use policies that you have with a particular company, I think that that to me is, I don't think that it's going to be, I feel like a lot of the fear is about the government possible overreach in this context is people having this parade of horribles about how the government's going to start prosecuting people for violating the terms of service for Facebook or for Instagram or for something else. And my perspective on that is that it's still going to be about looking at the intent of the person and what they were doing, and so it's not going to be as much a technical assessment of whether or not some particular provisions of an employment contract were violated or particular provisions of a term of service agreement. It's going to be looking at what was that person doing in accessing their employer's email server or something like that. And I think that's what I appreciate about the opinion in Nozzle 2 and the dissent in Nozzle 1, is that the judges there were very focused on the conduct of the defendant in this particular instance. And I think that the debate between the dissents and the majority opinion, which were a little bit flipped in those two cases, were how much should we be worried about the possible extension of any decision we make now to all these other apps or websites or anything else that people are using, and the dissent in Nozzle 1 and the majority in Nozzle 2 came down to looking at this person's conduct in this particular instance. He knew he was doing something wrong. He knew he'd been kicked off the system, and he still went back. And so that's how I think I would look at this and how I think most prosecutors look at it too. I don't know if anybody has a different idea.
So I spend my time advising a lot of companies and internet service providers and non-service providers on issues when there has been a breach of an entity's system. Sometimes when we go in, we conduct a internal investigation. This is much before law enforcement is even involved. We conduct an internal investigation under the purview of the attorney-client privilege. In conducting that investigation, we are able to determine, most of the time, whether the perpetrators are folks that are employees, former employees, complete outsiders, or they're elements of the advanced persistent threat, foreign state, nation state sponsored hackers, very sophisticated. And so in conducting our investigation to determine and to put the company and the board members in the best position to make decisions and to utilize the business judgment rule, to provide them with the advice necessary as to what to do next. And in situations where we have, based on our investigation, determined that there is, in fact, an internal actor that we may be interested in pursuing, either civilly or if we determine that it is, in fact, a crime, in our view, that we want to provide the information and report this information to law enforcement. And many times there are elements of restitution that come into play. There's elements of insurance coverage that come into play. And to utilize for instance, if you have a crime policy, a fidelity policy that actually requires to obtain any coverage, you have to first make a disclosure report to law enforcement. And so we will then consider whether we're going to make such a disclosure and report to the government as to what has happened. In doing that, and after the decisions in Nozels, much consideration and thought is given, and in the course of our investigation, as to if it is a insider and they had access to the system, some form of access to the system, whether that access for us, and the way we're going to present this, is in fact going to be deemed a violation of Section 1030, the Computer Fraud and Abuse Act, because it, A, exceeds authorization, or they had unauthorized access. Now, given the decision in Nozel, it's, for me, when I'm conducting my analysis and conducting this investigation and making a determination of what to do next, the line between unauthorized access and exceeds authorization has somewhat been blurred, because under Nozel now, if you had access to the system, the only way really you could go on a theory of a criminal liability in terms of whether you exceeded authorization is essentially if you were an internal hacker, right? So it's not going to be based on whether you had misused your, you actually had access and misused your authorization to use that information. So, you know, and before sometimes going in on a consulting basis, we always address compartmentalize the information to limit access, so that if there is in fact access, it is going to be deemed to be unauthorized to the extent that they have to actually hack into the system. Even though they have access, they have to hack into the system to obtain that specific information. But in cases where that doesn't happen, it really becomes difficult in saying after Nozel, from the company's perspective, whether the acts here, and yes, we look at what Vicki's talking about, whether there's, what was the intent? What's the evidence to establish the intent as to what was done and why it was done? But, you know, if I'm looking at an employee who had complete access to the system but did things that they weren't supposed to do and then misused the information or committed fraud, then I'm a little weary in terms of the theory and how we're going to go about doing that. And I may not even look at that point, addressing this from the Computer Fraud and Abuse Act itself, and may address, you know, other theories. And it might be a lot easier for me to try to put this case together on a wire fraud theory. And so, you know, that's various considerations that we have in kind of investigating and looking at cases from the company's perspective.
I suppose you're going to get into intent there, because if you look at a system administrator, we'll take Snowden as a bad example, who had access to absolutely everything. There's a very, very important role there, and that's another slippery slope.
Well, I was going to chime in on the same thing, but I want to challenge Vicki, and I'm going to ask Dennis to help me. You said you look at intent, but intent to do what? Statute needs to give you notice of what conduct you're not supposed to engage in. And I've never seen a statute that says it's criminal if you intend to do something that's bad. So how do you take it a step further?
So I think the concern animating the court in Nozzle 1, the reason why they were so concerned about the rule of lenity, and this is going to get a little technical, but so let me back up and say, A2 criminalizes intentional access in excess of authorization or without authorization to obtain information. A4, which was the provision that was at issue in Nozzle, is the same intentional access or access, but with intent to defraud. And I think, and so in Nozzle, because he had taken proprietary information, that's why that came into A4. And then A5 is accessing a computer and damaging it. And so I think with A4 and A5, it's people have fewer concerns about what the necessary criminal intent is because it's specifically built into the statute, intent to defraud, and that's something that's also found in other provisions of the law. For example, with access devices, I think the legislative history shows that language is supposed to track 1029. And then with causing damage to a computer, that's also more clear. You know, if you're intending to cause damage or recklessly causing damage, that's also clearly something that you're doing that is wrong, that's criminal. And so I think what happened in Nozzle, the court, when they were talking about the rule of lenity, they were very concerned about it because in this context, in A4, where there is intent to defraud necessary as part of the statute, they weren't so concerned. And that's why in Nozzle 2, the majority is saying, oh, you know, in this case, this person was doing something wrong. He was clearly acting without authorization. We're not concerned about all these other scenarios you're talking about where there might be password sharing. But in Nozzle 1, when the court was concerned about the other implications, one of the things I think they were concerned about was what would happen if you interpreted exceed authorization in a broad way because of A2. Because all you need to do there is to intentionally access in excess of your authorization or without authorization to obtain information. And just looking, if you just get onto someone else's account, someone else's computer, and you look at something in that account or computer, that's enough to violate A2 potentially. And so I mean that is a concern, but I think that something we were talking about earlier today is that potentially the answer in one of the Nozzle dissents, the court says, you know, perhaps the issue will be one day there will be a challenge to A2 as being too broad or too vague and not providing enough notice, or perhaps the answer is that the criminal act is intentionally accessing without authorization, such that your intent is to act in that way. And so that would be what would distinguish the conduct of a mother using her son's password to look at his email to see what he's up to versus what happened in this case or in another case where someone's perhaps getting someone's password but getting into an area where they know that they're not supposed to be.
Dennis?
Yeah, I'm trying to think of, Vicki is absolutely right that there's a huge tension between the dissension in Nozzle 1, 2 votes as opposed to 9, and in the panel opinion, 2 votes to 1 in the other direction. Obviously, there's going to be an en banc opinion. But let me, and I think it's important, let me try and illustrate it with an example. Imagine a statute that says that anyone, the elements of it are, anyone who threatens the security of the United States, element 1, and by doing so engages in an act of great violence, element number 2, shall be guilty of a very serious felony. Okay. You can have a case in which the acts of violence are gross and evident, and nobody's going to be worrying too much about the nuances of threatens the security of the United States because you're dealing with a very bad actor, right? He or she clearly acted in a heinous manner. But now let me posit that there's a lesser offense of that, a greater offense, which is that anyone who threatens the security of the United States is guilty of a felony. If you're only dealing with the second one, and an opinion comes out that says you satisfy the element of threatening the United States if you dare to criticize the president, but people aren't too worried because then the person went on and tried to kill the president, okay? But when you're dealing with the lesser, then you're dealing with a statute that simply makes it a crime to criticize the President of the United States. So what the difference was in Nozzle 1, what the dissent wanted to do is say, hey, this is a crime about fraud. So we don't have to worry too much about the definition of exceeds access. And what the majority pointed out is, wait a minute, there's a lesser crime here where the only crime is exceeding access. And if you define it in a way that everybody who uses their computer to send personal emails while they're on the job commits a federal offense, you're sweeping within the scope of the lesser offense a huge area of innocent activity. And they said, and this is true and everybody agrees with it, you must have a consistent interpretation. It's got to be the same. You can't define it more broadly when you want to sweep in people as opposed to fraud, and more narrowly in the later one where it might affect a large part of the population. And that is the same thing that comes up with Nozzle 2. One way to look at Nozzle 2 is it criminalizes password sharing, going into a computer where the owner hasn't given you a password to it, but someone gives you a password to it, which goes on all the time. If that's the crime, it's huge. How do you cabin it? And I submit that the majority in it said, well, we don't have to worry too much about that because, you know, we've got a fact pattern in the employment context where somebody was doing something that they didn't want to do, and we'll get to the rest of it when we get there. But that is what is left out there. And that is why, if you go on the internet and look up the Nozzle opinion, you are going to find hundreds and hundreds of articles in Fortune and other local newspapers about whether it is now a crime to share passwords. And they're valid questions. You can't duck the meaning of exceeds authorization and without authorization by leaning on the fact that other provisions of the Act would also require an element like fraud that makes you feel comfortable that you're dealing with real crime.
Question?
Yeah, if you have a company, and the company has a very clear policy, employees must log on with their own credentials, may not use anyone else's credentials, may not share their credentials with anyone else. What is wrong with prosecuting somebody who gives their password to somebody else?
Well, you have to come up with a definition of why that's a crime under the CFAA. Obviously, you can fire the person. Obviously, they may have committed a variety of crimes. Maybe somebody commits fraud. But the CFAA requires an element that they act without, they exceed access. And what Nozzle 1 said is we cannot have a situation in which you can read the statute and you don't know whether what you're doing is a crime because the person who defines whether it's a crime or not is the individual company and their individual policies.
I think you've hit the nail on the head. What you have is a constitution that gives the authority to prescribe conduct with criminal penalties to the legislature, Congress. But the Computer Fraud and Abuse Act, under the prong of unauthorized and exceeding authorization, now gives that authority to a company through its policies, through its commercial contracts. And that, I think, is the tension within the Computer Fraud and Abuse Act.
Again, I raised the issue I raised earlier, which is that what is the difference between me giving you my password and you're going to do something for me while I'm on vacation for the next 2 weeks, or me giving you permission through the access control mechanism to access certain files? I claim there is no fundamental difference between the two.
Vicki?
I think the majority in Nozzle 2 is sort of what you're saying, which is that there's a gut understanding of what it means to act without authorization, and if your company's statements, if your access is defined in such a clear way, then yeah, you're acting without permission. There are a couple of things I forgot to say that I wanted to bring now, which is that the default for the A2 violation, which everyone is so concerned about, is actually just a misdemeanor. And so for it to be a felony, there have to be other elements that make it a little bit more serious. And so if you're talking about felony access, then it will be something it will have to have been access taken in pursuit of another tort or crime, or loss will have been involved or something. And so that might be something that ameliorates some people's concerns about it. And then the other thing that I wanted to say in this context is that this law is a little clunky, particularly when you read it. It's got all these different provisions, and you kind of have to match them together with the penalties. But it's actually done a pretty good job of being able to of providing the government with tools to go after conduct that hurts people and is wrong and is commonly recognized as criminal by a lot of people. And so even though we are talking about a law that was written ages ago, when I was looking through it in preparation for this panel, it struck me that there are things that we talk about today that haven't even happened yet that can still be addressed by the law. So for example, when you're talking about the Internet of Things and how soon cars will be self-driving and there will be all these other things that will be controlled by computers that people could hack into and cause serious harm, I mean, that can be addressed or that can be prosecuted by the government under A5 as transmitting malicious code or something that causes potentially physical injury, and that's pretty impressive. And so that, to me, speaks to the virtue of having a statute that may be a little bit broader, arguably, but has to deal with a situation where you have constantly evolving technologies.
One important thing for the importance of this topic is that the CFAA is both a civil and a criminal statute. And therefore, what you're talking about when you're talking about interpreting these provisions are interpretations that the government might say, well, we would never prosecute somebody on the periphery of this. We don't have time for misdemeanors, okay? We're only after serious felonies. That doesn't mean that you haven't created a cause of action in the employment context. To have the CFAA be a weapon that's used when somebody sues for sexual harassment or wrongful discharge and so forth and so on. So you've got to include that aspect of it in the equation. The other thing, and this comes in the dissent in Nozzle 2, is the use of the CFAA. In this case, we've talked about conduct that clearly was inappropriate, but on the part of the employee who shared her password, or even though it was not criminal, going in and giving information away under Nozzle 1. But the role of private companies of nearly $1 billion in value who hire law firms of enormous magnitude and hire lawyers out of a United States Attorney's office, and soon after they're hired, they are back in the U.S. Attorney's office, essentially saying, we have a major civil suit that we want to file. We have to file on August 1st. We're going to get into a wrongful arbitration and so forth. We want those arrayed on certain computers before then, before we file, because we don't want anybody to know that this action is coming. And really, really explicit lobbying by former U.S. attorneys of their erstwhile supervisors to prompt a criminal prosecution under the CFAA rather than merely going the civil route. And I think everybody in the room recognizes that if you're a plaintiff's lawyer of any kind, just get the government to go first on a criminal case and sit back and relax and have your work done for you. So another element of this is with these unclear statutes and their civil implications about whether fuzziness in them can lead to that kind of disparate enforcement.
Okay. Peter, and
I have
then
a very
I'm
quick
want
comment.
Ray to
Very
chime
quick
in.
comment. Vicki mentioned the Internet of Things and hackable automobiles and hackable automated highways. The current legislation that has been proposed, the anti-hacking law, makes it illegal for researchers to find the flaws in those systems. And I believe this is a fundamental problem, that if the good guys can't help, we are shooting ourselves in the foot.
Do you have any?
So, by the way, I think on the IoT issues, the Internet of Things, there are going to be significant issues because many of these devices, the IoT devices, are not designed with security in mind. And a lot of the IoT devices are, instead of being put together, for example, I don't know, by IBM. It's being put together by a T-shirt manufacturer or a shoe manufacturer, which is not in the business. And as the FTC said in 2015, that the IoT devices have to be made with security in the forefront, and we don't see that. And so there's going to be a lot of these issues where the product that's been designed is what Peter was talking about, where there are ways to get in, and maybe it's a feature or it's a flaw. And so there's going to be very interesting cases, I think, in terms of civil cases under 1030 or prosecutions that relate to that in accessing IoT devices. But to address Dennis's point, there is, as a company, if I know that there's been an access to my system and I want to utilize somebody who's a former government official who has expertise in this area, I don't see that as a crime, Dennis. And I would disagree that the company utilizing this as a threat to go after an employee, say, hey, we're going to prosecute you. Well, under Rule 5-100 of the model rules, you cannot threaten a criminal prosecution to get an advantage in a civil case, first and foremost. And so that is something to keep in mind, be very wary of. And so if a company is utilizing its resources to prosecute a crime that has taken place and they've been attacked or their systems have been breached or their information has been accessed that should not have been accessed, whether it's an employee or not, and if they're going to expend their resources to do that, then I don't see what the issue would be there. Now, if we're saying that there's some form of and I'll let you, Dennis, to say, if the court's decision is that, well, if somebody's going in as a former government official and now presenting a case to the government, that shouldn't be done. Well, I think there's rules in place that address that. So I'm not so sure that I'm convinced that is, in fact, an issue, and I think that the model rules address most of those concerns.
And certainly the government still is going to have to meet its burden, and so I can't imagine any person taking a case just based on the say-so of someone that they formerly knew, because you ultimately will be responsible for presenting this case to a jury and proving beyond a reasonable doubt that all the elements have been met.
Well, and look, there's a whole spectrum of activity here, but as a general rule, the United States Attorney's Office, and Vicki, correct me wrong, maybe it varies from district to district, just doesn't prosecute, let's say, a fraud case involving less than $50,000. It will generally, I'm sure there are some exceptions perhaps where government funds are involved and so forth, but it generally will leave that to state courts to deal with as a state crime. This was a case in which, KFI went to the U.S. Attorney and claimed a loss of $1.5 million in the lead up to prompting them to do the raid. When the case was over and the court actually assessed the monetary value of the information here, it put it at about $19,000. So all that I'm saying is that there's an awful lot of aggrieved parties in the world who feel they've been aggrieved in a civil way or even in a criminal way, who are not going to get the United States Attorney to mount a prosecution that's gone on for 11 years without, a particular wallop at the lobbying level. Judge Reinhardt didn't accuse anybody of misconduct. He just pointed out as a reality of the criminal justice system and federal criminal justice system in the United States today.
Okay. I have 2 points I want to throw out to the panel. Since I don't know which one is more important, I'm going to throw them both out and let you guys jump up for them. The first is something Vicki said, which was the government has to carry its burden. And that means that, I think you mean, that you're going to be very careful about what wrongful conduct you're going after. But as Dennis said, this is both a civil and a criminal statute. And indeed, there are civil cases that have been brought on the Computer Fraud and Abuse Act on what might be considered fairly questionable, wrongful types of conduct, whether it's authorized or unauthorized conduct. But the burden is no longer beyond a reasonable doubt. It's more probable than not, or is clear and convincing evidence, and it becomes a problem on the civil side. That's point number one. Point number 2 has to do with researchers. And I think there have been cases where people, whether they're formally researchers or not, but people who have been hacking to find flaws and then wish to report those flaws. And there's one case, correct me, I'm horrible with pronunciations.
Arnheimer's how I'd say, yeah.
Right, and can you explain what that
Why don't
case
you
is?
go ahead, yeah.
Very briefly, he and somebody else found what we might call a bug in AT&T's, one of AT&T's networks, where if you, it was designed so that AT&T would recognize your laptop computer or your tablet and would populate your email address for you. So all you had to do is type in your password, and it would check your computer's ID number. Well, what he did was to change or cause his tablet to keep scrolling through, changing its ID number, and he was amassing the email addresses of over 100,000 people. And he presented that as, I have found a bug in your system. And his reward was a criminal prosecution, which was ultimately overturned by the Third Circuit Court of Appeals on the grounds that venue was brought in the wrong jurisdiction. So those two things. One, how do you reconcile the fact that this is both a civil and a criminal statute, and therefore you've got a watered down element of what you're doing that's improper? It's going to carry over to the civil side. And are we really shooting ourselves in the foot by criminalizing people who just want to find out and identify what the bugs are in our commercial systems?
And Andy, let me add one more aspect to that, and that's, to what extent do you think prosecutorial discretion plays a role in charging cases like that, or just bringing cases like that?
All right. Vicki, I've been going to you all day. I'll do it again.
I'll answer the last one, which is that, that is a big part of our system. It's not unique to the CFAA that we rely a lot on prosecutorial discretion for what to go after. If you Google, prosecutorial discretion and broad laws, you see a lot of discussion of it. Like, for example, in the drug law context, there are people who write about how multiple of our presidents should have been or could have been prosecuted under federal drug laws. And so, yes, is the short answer, but I think that's just part of our system.
One thing about the CFA, one of the more interesting cases, which is now history and I think is dealt with by Nozzle 1, was the Laurie Drew case. And the facts of it, as I remember, is that a teenager in somewhere like Nebraska was accused of trolling a classmate over the internet that the classmate committed suicide. And I think she faced state charges in Nebraska or Kansas or whatever, but federal charges were brought under the CFAA in California, in Los Angeles, on the theory that she had violated the CFAA because it was against the policy and clear regulations of Facebook to engage in this kind of harassment. I believe she may have been convicted.
I think it was the mom of a student. It was
the mother of a student who was harassing another student.
Right. So the violation of the terms, and that's why Nozzle 1 people talk, or Nozzle 2 people talk about sharing passwords, and then this case people were talking about just violations of terms of service generally, and it was because the charge theory for exceeding authorized access was that she had violated the terms of service by pretending to be someone she wasn't.
Right. And well, it's essentially though, wasn't she using her daughter's password?
I think she made up a profile.
Oh, made up a profile. But again, it was a case in which depended not on something spelled out in the statute, but depended on the particular use policies of Facebook. I believe it was dismissed at the trial level. It never produced an appellate decision. I think that Nozzle 1 would clearly say that that is not a CFAA violation, but it's illustrative of the, again, of the cases that could not possibly have been imagined when those terms were framed in 1986 that have since arisen in the very different world that we exist in.
And if you don't mind, let me just add a couple references just for context. The statute that we're talking about is 18 U.S.C. 1030, And the cases are U.S. versus Nozzle. That's Nozzle 1. That's 676 F3rd 854. That's a 2012 case. And then there's a 2016 counterpart, which is Nozzle 2. So I just...
And one thing is clear is that, I think it's clear, is that you're going to be hearing about this at the Supreme Court level. Because without authorization, as I said, is the second prong in Nozzle 2. But when Nozzle 1 came out, it was written by Judge Kaczynski. It was 9-2 opinion. And I saw him afterwards and I said, you know, your opinion constituted the greatest cert petition the government could have had and the best brief on the merits that we could have had. Because he was absolutely explicit in saying, I am creating an enormous conflict between the circuits. You know, the 5th is over here, the 11th is over here, the 8th is over here. I think I've got the such and such to go with, but it is just the conflict couldn't be clearer, and here's why you should come out my way. We got calls from every major Supreme Court firm in the country saying, oh, you want a little help with your case in the Supreme Court in Nozzle 1? I said, well, let's see what happens. The government ultimately decided not to petition for cert. I have heard different theories. It was an interlocutory appeal, and maybe that wasn't the right vehicle to take up. Maybe the government was happier to live with the conflict and get it resolved. Because in between our decision and the time when cert would have been due, the Fourth Circuit absolutely came along with Judge Kaczynski, deepening the conflict. And since then, in a case that was famous for another reason, the Cannibal case in New York, where a police officer was charged with a conspiracy to murder on the grounds of these gruesome exchanges he had through his compatriots about how they were going to cook and eat each other's wives. And the big part of the decision was about whether that kind of talk, however reprehensible, constituted conspiracy. The court found that he didn't. But in the second part of it, he was charged with a CFA violation for going into police computers to get addresses for various people that they were planning to have for dinner. And the court went along with Nozzle 1, found that that was not exceeding authorization because he was authorized to enter those parts of the computer. So
Peter?
the exceeds access is yet to be settled definitively, and there'll be more to be said on without authorization as well.
Great. I want to throw the international curveball at this one. This is the ultimate slippery slope for your lawyer friends and your prosecutorial friends. If I can masquerade as anybody else, and you notice we're being very careful not to accuse the Chinese and the Russians of recent hacks because it might devastate counterattacks from them, and we don't want to have that, despite the fact that all of our systems are already broken and easily breakable. The international curveball is that you can masquerade as coming from anywhere. And so tracing back with any certainty that you really know who is the culprit is very difficult. Let me give you the example of ransomware, where suddenly you get an email saying you have to pay how many bitcoins, and that's supposed to be an anonymous virtual currency. And then you have no way of tracing where the hell this guy is coming from, or this agent or robot or whoever it is who's generating this. It could well be a robot going after thousands and thousands of accounts that they've already figured out how to break. So if you can't identify the culprits and you can't prosecute in countries where there's no extradition to this country, and where the laws are much more liberal. For example, in the Netherlands, hacking laws are almost non-existent, and they are rather proudly honoring the constructive role that the white hat hackers can play. Let me just throw that out. I think you wanted to get into that topic anyway, but let's see where it goes. What do you do in that case?
First of all, I'm not supposed to be answering these questions.
You are. Why not? We're putting you on the spot now. Go ahead.
I think there's a consensus against what we would call self-help, where if you think there's a bug, you check it out yourself, and then you make arrangements to have it corrected, and sometimes that's by publicizing it. But as I said, there's a consensus in the legal community, maybe not in the, let me rephrase that, not in the research community of self-help. And I, in a prior life, I was a grad student in physics and computer science, so I kind of have a feel for the research community. And that's something that the legal community and the legislatures, I think, don't seriously understand, that this is simply the way researchers work.
I have a proposed solution to that one. Suppose you are Microsoft and I am just a fly-by-night researcher. I go to you and I say, look, I want to have a piece of paper that says you're not going to prosecute me if I find a bug for you and report it to you, and do not publicize it until you have fixed it. I want to write a research paper because I've found a beautiful method that allows me to find bugs that nobody's found before. But I can't publish it if you're not going to let me publish it.
You've already committed the crime. If you've hacked.
No, I haven't hacked yet.
You've designed a method.
Well, I know that but the method itself hasn't been implemented yet. I have a paper design of something that would enable me to find flaws in many systems.
But the decision whether or not to prosecute does not belong to Microsoft.
No, that's true. But suppose they write a piece of paper saying that I am absolved of civil prosecution.
So you have authorization.
I have authorization.
Then you don't have a violation of computer fraud and abuse.
That is the whole point. And so there is a potential solution to this
But
problem.
is there third-party information that you may be accessing?
Oh, there's tons of it. It's all over the place.
And then do you have a violation of the Stored Communications Act?
Okay, so again, I've come back with another slippery slope. I mean, I can go on with slippery slopes. They're all over the place. They're everywhere. And
I'm sorry,
yeah, go ahead.
Great.
And just on the issue of the, Andrew, you mentioned self-help. It's an important part with sophisticated companies that have robust security infrastructure. When they are compromised and they try to sometimes go over and above trying to identify the hackers, and if there's, let's just say, a DDoS attack, and they're in an effort to try to stop the DDoS attack, and going back to what Peter was saying, that using IP anonymizers, and you cannot really tell where the attack is coming from, or you're not so certain, where the company will then take an offensive measure to try to what we call hack back the hackers. That in and of itself could be a Section 1030 violation, which is what we've been talking about. And so that's a tremendous concern. And so when we're involved in these investigations and the company is already in the process of dealing, and sometimes when we go in, we're dealing with an active live attack that's going place, whether it's in a ransom situation or otherwise, to be very careful that they do not utilize a self-help measure. There are different ways of doing things if you're setting up a honeycomb to attract folks in, and you can get information while they're in your system, but to then go above and beyond and try to prevent that and retaliate is tremendously, while it's very tempting, if you have the resources and the capability to do something like that, but yet very dangerous.
One of the other issues that was mentioned during the course of NOZL 2 that hasn't been addressed at all yet is who authorizes? Who authorizes? That is to say, the assumption there was that some people they had a password, they don't have a password anymore, they're without authorization. An interesting twist in NOZL was that this was the KF database. During the period of time involved here, he was he was permitted by KFI, because he was working as a contractor, to get any information that he needed out of their database. He could call up any of their employees and ask for any information. Now, of course, it was under the understanding that it would only be used for his contracting work as opposed to his own work. But that gets back again into Nozzle 1, you know, is that without authorization if it's merely misusing information as opposed to improperly getting a hold of it. But I was thinking of something that occurred not that long ago when I was talking to a sales representative for one of the on-learn research entities. I mentioned the name. I think there's only 2 or 3 that people are aware of. And I said, you know, the monthly bills are high. You know, how can I reduce our monthly payout on this? He said, well, you've got 7 passwords. You know, if you cut it down to 3 passwords, the monthly rate goes down. And of course, you can just take the password and give it to the people, you know, who used to have their own password. They can use it. That's fine. But, yeah, everybody does that. So is that authorization? It would be a situation where somebody who once had a password into X law now is password sharing with someone, having had their password revoked, but they've been told by a salesman that as far as they're concerned, it isn't a problem to share passwords. And I suspect within the legal community, the sharing of passwords to get into legal research entities is ubiquitous. Just one example, but they can be multiplied in this context.